Equal justice under law.
Never before has the U.S. Supreme Court involved itself in the election of a president. The demonstrators outside this morning know this and know that the judgment handed down could swiftly end this extraordinary election saga.
I think that those of us who care about the rule of law and the reputation and role of the Supreme Court in our society have thought a lot about why the Supreme Court stepped in.
All right, we're officially saying that Florida is too close to call because of a recall.
I'm sure that the justices on the Supreme Court were saying, why bring this to us? Because whatever we decide, one way or the other, people are going to hate us for it. People are going to disagree with what we do. But at the end of the day, the justices were persuaded that it was something that was their obligation to do.
They have agreed when they will applaud as we welcome the two candidates, Governor Bush and Vice President Gore.
In the first year of the new millennium, the world watches a U.S. presidential election unlike any other. On November 7, 2000, ballots are cast and votes are counted for Vice President Al Gore and Texas Governor George W. Bush. States certify results and declare their winning candidate, but not in Florida. Neither Bush nor Gore have enough electoral votes to claim a national victory. Whoever receives Florida's electors will become the 43rd President of the United States.
It has been one of the closest presidential elections in history, and we do not know who the next president will be. There's a recount in Florida, as I'm sure everyone knows. Lots of people are going to Florida to be involved in that recount.
I was on an airplane headed for Los Angeles for a law firm meeting, and I got a call somewhere over Kansas, I think it was, headed west. At 35,000 feet. I was asked whether I could get to Tallahassee right away to assist with the litigation that was developing all over the state of Florida.
The Vice President's team, they needed somebody who had experience arguing in the Florida Supreme Court, and they asked me if I would come down and do that. I went down with one clean shirt, but I thought at that time that things were going to move pretty quickly. We all did.
Federal law provides a safe harbor deadline for all states to finalize election results. This ensures that there will be a president sworn into office in January. The safe harbor deadline is December 12, 2000. There are 35 days to determine the results of the Florida election.
Just over 1,700 votes out of millions cast separate Texas Governor George W. Bush and Vice President Al Gore. A margin so close, the state has now mandated a recount of all the votes.
Was if somehow this gets so tied up, all this litigation, that Florida does not certify its electoral votes by December 12th, there's the possibility that they just wouldn't be counted in the electoral.
The pressure was immense because every day that went by brought us closer to the deadline. There has to be a new president on January 20th. There's no provision in the Constitution for an interim or temporary president.
The day after the election, Florida commences a machine recount of votes. On November 9th, the Gore campaign requests a manual recount instead in 4 particular counties. But recounting votes is not as straightforward as it sounds.
You had a situation in which Florida used 3 or 4 different kinds of voting machines. So you had punch card ballots in one county, and in an adjacent county you had entirely different machines. You had a Florida state law procedure that had been followed for decades that allowed individual canvassing boards to do manual recounts of ballots and try to determine the intent of the voter. So you had a series of issues that made the recount at the the Florida state level, difficult and very contentious.
There are absentee ballots, there are veterans ballots, overseas ballots. There are questions about the counting process. There are questions about the integrity of the ballot itself, how it is structured, whether people understood what they were voting for. There were statements, there was litigation, there were developments in every level of the Florida state courts as well as the federal courts. So all of this was a perfect storm.
All recounts must be finished by 5 p.m. on November 14th, per Florida law. The Florida Secretary of State refuses to accept any further votes after the deadline. The Gore campaign files an emergency motion in state court to allow ongoing recounts to be completed. Immediately, dozens of other lawsuits are filed all over the state. The Florida Supreme Court decreed that manual recounts could continue and should be included in the final certification.
We should complete hand counts already begun in Palm Beach County, Dade County, and Broward County to determine the true intentions of the voters.
The votes of Florida have been counted. They have been recounted. And tonight they have been certified.
So there were lawyers all over the place trying to find ways to eke out a few more votes.
The Florida Supreme Court has ordered Secretary of State Katherine Harris to accept at 5 p.m. next Sunday the amended vote.
You had demonstrations throughout the state in terms of the canvassing boards. In Miami, you had the so-called Brooks Brothers riot.
You know, the only way this recount is going to be resolved with any legitimacy, Charlie, it's clear that the local county authorities can't do it, the local legislators, the local courts, the state Supreme Court. This may have to go to the Pope.
Florida Supreme Court justified their tactics by rendering a decision right around Thanksgiving that year of 7-0 in favor of efforts to change the timing and to change the rules in ways which helped the Al Gore candidacy. We thought that that decision was wrong and was inconsistent with the United States Constitution, and we took that case to the United States Supreme Court.
A huge legal gamble pays off for the Bush campaign. The justices agree to its urgent request to review whether the Florida Supreme Court's order delaying a final vote total and allowing recounts to continue violates the U.S. Constitution and federal law.
On December 1st, the Supreme Court of the United States hears Bush versus Palm Beach County Canvassing Board in response to an emergency petition from the Bush campaign. For the first time ever, a Supreme Court oral argument was recorded and broadcast on the same day. At issue was whether the Florida Supreme Court violated the Constitution or federal law by overriding the Secretary of State.
The Supreme Court had never intervened to decide a presidential election. Particularly, it had never intervened in really any case involving an election without allowing the state to complete its vote count. You can argue whether you ought to have manual recounts or not, but Florida had had manual recounts for decades, and a majority of the states in the United States had manual recounts.
It's ironic that the people that think the United States Supreme Court should not have been involved in a federal presidential election would also feel that what the Florida Supreme Court did, what was happening in Florida, which would determine the outcome, was perfectly okay.
We all wondered how prepared we were to deal with the issues that were being raised.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States.
The Supreme Court listened to our arguments, decided that they could not even figure out what the Florida Supreme Court was doing in its 7-0 decision changing the rules, and voted unanimously to set aside the Florida Supreme Court decision and send it back to the Florida Supreme Court for a further explanation. The Florida Supreme Court then ignored what the United States Supreme Court did and rendered another decision.
On December 8th, the Florida Supreme Court orders a statewide manual recount the next day. The United States Supreme Court stops the recount in response to an emergency request from the Bush campaign. The court announces it will hear oral arguments for Bush versus Gore on the morning of December 11th. Both parties only have 24 hours to prepare and file written briefs for one of the most consequential cases in American history.
What they were doing was they were totally taking away the power of Florida to determine its electors, as opposed to allowing Florida to determine its electors subject to possible further review. And that's what, in a sense, happened in Bush v. Gore. The power to determine the President of the United States under established precedent and procedures was taken away from the voters and decided by the United States Supreme Court.
We'll hear argument now on number 00949, George W. Bush and Richard Cheney versus Albert Gore et al.
The tension that day in the United States Supreme Court, December 11, was palpable. The court was filled, the crowd was intense.
It was a whirlwind of activity. It was a very accelerated briefing schedule, it was a very accelerated argument schedule, and it was a very accelerated decision-making schedule.
There were cameras all the way around the Supreme Court or satellite facilities. There were rivers of cables surrounding the Supreme Court. It was like crossing the Delaware. This was a center of attention for not just everyone in the United States, but throughout the world.
You'll hear from David Boies, lead attorney for Vice President Al Gore, Governor George W. Bush's lead counsel, Ted Olson, and Joe Clark, lawyer for the Florida Secretary of State, during this 90-minute session.
So we were arguing, first of all, that the Constitution gave the power to the legislature to determine how votes would be cast and how votes would be counted, not the courts. But we were also arguing that it violated the Due Process Clause of the Constitution and the Equal Protection Clause of the Constitution to count people's votes one way in one county and another way in another county.
Under intense media scrutiny, the flaws in Florida's system became clear.
Vote-o-matic machines and conflicting rules about ballots and fuzzy rules about what is a vote.
It's unprecedented, so close. And of course, fitting into the drama, it couldn't be more bizarre than the fact that Governor Bush's brother is the governor of the state of Florida. So the drama is just so, it's extraordinary. You couldn't write this.
Historically, the Supreme Court would always allow the state to finish and then would judge what kind of job they did. Here they took the case in the middle of the recount, stopped the recount, didn't give the Florida courts even the opportunity to demonstrate that what they were doing was consistent with any standard that the Supreme Court might apply.
Do you think that in the contest phase, there must be a uniform standard for counting the ballots?
I do, Your Honor. I think there must be a uniform standard. I think there is a uniform standard. The question is whether that standard is too general or not.
Without a single reference to this court's December 4 ruling, the Florida Supreme Court issued a new, wholesale post-election revision of Florida's election law.
They were basically all involved very actively in the argument by asking very difficult questions, interrupting themselves, interrupting the lawyers, pressing forward with difficult questions that reflected their particular take on the issues.
There's a specific grant of authority to the circuit courts. There's no reference to an appellate jurisdiction. It may not be the most powerful argument we bring to this court.
I think that's right.
And your mind gets filled with doubts. Other people are making arguments saying that you're wrong, you should do this rather than that. At the end of the day, you have to have confidence in your own judgment and the work that you've done and your instincts.
A clear intent of a vote should count. Where there's a clear intent on the ballot, it should count as a vote. Can't you reasonably get to the majority's conclusion?
I don't believe so, because we know different standards were being applied to get to that point, and they were having different results.
Thank you, Mr. Olson. The case is submitted.
We made the arguments at 10 to 11 o'clock, something like Monday morning, and the Supreme Court decided the case by 10 o'clock the next night.
At 9 p.m. on December 12th, the United States Supreme Court issues its decision on Bush versus Gore. The justices vote 7-2 that the Florida Supreme Court's recount was unconstitutional under the Equal Protection Clause of the 14th Amendment, and 5-4 that no constitutional recount could be conducted in the time legally remaining to do so before the safe harbor deadline.
You might be able, in theoretically, to come up with a constitutionally sound recount provision.
The judgment of the Supreme Court of Florida is reversed.
What has happened here is a per curiam decision has said that
Those in the minority had strong words, one calling it a self-inflicted wound. Another said that while we may never know who won the election, the loser is the nation's confidence in the judge as an impartial guardian of the law.
And what they did today may be debated for years. Some of us may deeply disagree with it, but it is the law of the land. And this judgment of the court does not appear to me to leave any latitude to return to the Florida courts and get any different decision than what was rendered tonight. It appears that the last vote in Florida has now been counted.
The majority of the justices on the Supreme Court decided a couple of principles that the Due Process Clause and the Equal Protection Clause required a consistent, uniform way to count ballots once an election takes place, and that there were deadlines set by federal statutes that had to be obeyed with respect to the timetable, and the time was up. So the Supreme Court decided that an orderly resolution consistent with the Constitution was to keep the rules in place as they had been at the time of the election, and not to change the rules from county to county or place to place, and not to change them on the fly after the election.
There were numerous prudential standards that the court has set up that limit when it takes cases and which cases it takes. The court abandoned those prudential rules to reach out and take this case, regardless of what language that was used may say. We place our faith in our least democratic institution. 9 people appointed for life, never elected by the people, and we say to them, make these decisions for us. And we do that to try to take certain decisions that we believe are critical to liberty, due process, our democratic institutions, social justice, and hand it over to people who we have consciously insulated from political pressure, because we want them to be made not just based on the majority at a particular moment, but based on enduring principles.
I've argued now 65 cases in the Supreme Court, and I've won some and I've lost some. And I do respect the integrity of the justices and the importance of the system, the independence of our judiciary, which is topped at the very pinnacle by the United States Supreme Court. And I think it's important that we in America respect that institution, even though we may not like or agree with the outcome of a particular case.
I think that people recognize that in our society, we've given the power to decide questions like this to the United States Supreme Court. And even though we may disagree passionately with the way the court decides a particular case, we believe our democracy is strong enough, durable enough, so that we can accept that result. We're going to have another election in 2 years or 4 years, in which we will have another shot at winning. And it's the confidence in the durability of our democracy that I think gives us the willingness to accept these kind of decisions.
The institutions of our government dealt with a very difficult situation, and everybody involved in that process under enormous pressure did not crack. History will judge that.
Thank you.
I think Ted is an outstanding lawyer, outstanding person. I don't know of a better lawyer in the country. I've never dealt with a better lawyer. I like it a lot better when he's on my side than when he's on the other side, particularly in a Supreme Court argument. Being against him is a uphill battle, and he is somebody who embodies the character, the commitment, the courage that we need in our society and in our justice system. He realizes, as I do, that the person on the other side is not your enemy. The person on the other side is fulfilling the same role that you are fulfilling in our democracy, in our justice system. And that is the role of reasoned, zealous, but honest advocacy.